Good morning and welcome to the South Carolina Public Service Commission. We are back on the record on 2025-250E. We have one or possibly two public witnesses this morning, and we will deal with that before we get an actual hearing. Present in the hearing room are all commissioners. Ms. Westner Hill, if you would please review where we stand in this case.
Yes, sir. Thank you, Mr. Chairman. As the Chairman mentioned today, this is the continuation or resumption of the hearing in 2025-250E. This docket concerns the application. Excuse me, I've got the wrong thing there. I apologize. I've got it. This concerns that. Thank you, sir. This concerns the joint application of Duke Energy Carolinas LLC, North Carolina Electric Membership Corporation, Central Electric Cooperative, for a certificate of environmental compatibility and public convenience and necessity for the construction and operation of a new combined cycle generating plant in Anderson, South Carolina. The clerk of the commission noticed these proceedings and the hearing to begin and to resume today on February 20th, 26 at 10 a.m. to receive evidence and to hear witness testimony. Should the hearing at this time need to carry over from today to another day, the hearing shall continue each day thereafter of February 25th at the call of the chair. Mr. Chairman, following the customer public hearing portion, there is one preliminary matter to address prior to the resumption of the hearing.
All right, thank you very much. And before we go there, I'd like for all the parties to please introduce themselves, beginning on my left.
Good morning, Chair Powers, Vice Chair Williams, members of the Commission. My name is Katie Brown. I'm here on behalf of Duke Energy Carolinas LLC. Here with me this morning are Sam Wellborn, also in-house counsel at Duke, Ashley Cooper from the firm Baker Donaldson, and Lyle Trawick from the firm Robinson Gray.
Thank you very much and welcome. As to interveners, next, South Carolina Coastal Conservation League, Upstate Forever, and Vote Solar.
Thank you, Chair Powers. Kate Mixon on behalf of the South Carolina Coastal Conservation League, Upstate Forever, and Vote Solar. And with me here today is my co-counsel, Thomas Gooding. Our other co-counsel, Menashe Magarera, is unavailable today. He had another conflict that came up. If the hearing goes into tomorrow, he may be available, but we would ask that he be excused from today's hearing.
Well, I think with the two of you, you're well represented. Welcome. Mr. Willoughby, what you got?
There we go. Good morning, Mr. Chairman, members of the Commission. My name is Mitchell Willoughby. I'm not representing an intervener. I'm representing a joint applicant in this proceeding. Our client is North Carolina Electric Membership Corporation. With me today is Tim Dodge, Regulatory Counsel for North Carolina Electric Membership Corporation. He's been admitted pro hoc vici, which we appreciate very much, and together we will represent NCEMC in this proceeding.
All right, thank you very much and welcome, Mr. Dodge. As far as Central Electric Power Co-op, Mr. Walsh.
Chair Powers, Vice Chair Williams, Commissioners, good morning. Court Walsh. And today with me is my co-counsel, Bailey Jackson, sitting to my left. We're from the Robinson Gray Law Firm, and we're representing, obviously, Central Electric Power Cooperative. Our co-counsel, Frank Ellerby, also will not be joining in person today because of a conflict, but he may be available virtually depending on his schedule and how long the hearing may go. Similar to what Mr. Willoughby said before, we're not representing an intervener. Central Electric Power Cooperative, of course, is a joint applicant, and we look forward to the hearing today. Thank you.
Yes, I was just kind of going across.
Understood. Thank you.
Office of Regulatory Staff.
Good morning, Chair Powers and members of the Commission. Appearing on behalf of ORES, my name is Claire Binge, and my co-counsel today is Chad Torrey.
Thank you very much. All right, Mr. Bachman, I'm going to turn it over to you at this time for your witnesses.
Thank you, Mr. Chair. At this point, we have on the line Anna Izzard. Ms. Izzard, can you hear me?
Yes, I am here.
Thank you, ma'am. If you would please affirm that the testimony that you're about to give represents the truth, the whole truth, and nothing but the truth.
I do.
Thank you, ma'am. Will you please provide the commission with your name, the name of your street and your town, but not your street number?
Yes, my name is Anna Izard, and I reside at Two Notch Trail, Easley, South Carolina.
Thank you, Ms. Izard. And are you a Duke Energy Carolinas customer?
I am.
Thank you, ma'am. You may begin your testimony. You will have 3 minutes. We will play a bell when your 3 minutes have elapsed. We ask that you not hang up and that you remain on the line, as commissioners or parties may have questions for you following your testimony. Thank you, ma'am. You may begin.
Okay, thank you. Good morning. My name is Anna Izard, and I'm speaking today to testify against the proposed Duke Energy plant in Anderson, South Carolina. The discussion around this plant has been problem-focused. Duke Energy says Anderson County's problem is that we don't have enough energy to meet the demands of growing populations. Director of Economic Development, Burris Nelson, says Anderson County's problem is that we need more economic development for the county to attract industry. And Superintendent Brenda Kelly says Anderson County's problem is that there is not enough money for schools. All three agree this power plant is the solution. With this power plant, we're promised more power, more stimuli, more money, and consequently, the plant has been presented as a necessary step for Anderson County. I hear Duke Energy, Director Nelson, and Superintendent Kelly. Building this power plant is an approach to addressing these apparent problems that plague our county. But I have yet to hear someone ask, is this the right solution for Anderson County? So I will. Does the right solution for Anderson County open the door to mass industrialization? Because this plant does. Does the right solution for Anderson County destroy wetlands, threaten our environment, and add pollutants to our air? Because this plant does. And lastly, does the right solution for Anderson County indiscriminately threaten the health of her residents, men, women, children, young and elderly, rich and poor alike? Because this plant does. The construction of this plant is being simplified to matters of business and economy, tax benefits, and future prosperity. And these are all hypothetical matters, expectations, projections, estimates. Few of the benefits that are being touted for this plant are actual knowns. Conversely, many of the consequences for this plant are known. It is a known fact that constructing this plant in its presently proposed location will threaten the health and safety of our environment through the geographical manipulation of county lands that will have negative consequences for our water sources and wetlands. It is a known fact that the operation of this plant will generate air pollutants called fine particulate matter, which contribute to cardiovascular and respiratory medical events, including but not limited to heart attacks, asthma attacks, increased instances of cancer, and premature death. These knowns are consequences Duke Energy and Anderson County willingly welcome for our residents today, all in the name of unknown future. So let me ask another question. Exactly what is or who is this future that Duke Energy and Anderson County are trying to prepare for? Undeniably, a part of our future is our children. So is the right solution for Anderson County one that jeopardizes our children's health? How could the right solution for Anderson County be one that is known to cause developmental delays? And how could the right solution for Anderson County be to look the children who carry that very future on their backs, to look the children of Varnus Elementary School and Homeland Park Elementary School and knowingly put them at risk and in harm's way with the construction of this plant? How, in the name of the future, can we simultaneously stunt, jeopardize, and even kill that future? The answer is quite simple. We cannot. While preparing for the future is prudent, forfeiting the well-being of our land, air, and residents is foolish. As I close, I turn our attention once more to the idea of what is right. There's a saying that goes, might is right. In one interpretation, it suggests that large corporations and institutions like Duke Energy and Anderson County control the narrative through their might. They decide what is right. Another interpretation of this quote would be that what might be in the future is enough to declare an imperfect, flawed design right for our county and her residents. I reject both, and we should reject both. Neither the mighty influence of a corporation nor the might-be future makes this proposed plant the right solution for our county. Choosing to support this plant is choosing to support the construction of an institution which will knowingly decrease the quality of life for current residents and will knowingly decrease the quality of that often touted future. This plant is not for our future. This plant detracts from our future, and we would be fools to support this measure. Might is not right in any interpretation of the measure. Thank you.
All right. Thank you, ma'am. Any questions from the company?
No, Mr. Chair.
All right. North Carolina Co-op?
No questions.
Central Electric Co-op?
No questions. Thank you.
All right. Any questions from SACE, CCL?
No questions, thank you.
All right. And Office of Regulatory Staff?
No questions, Mr. Chair.
All right. Are there any commissioner questions? Hearing none, thank you very much for your testimony, Ms. Eisert, and that is now part of our record.
Mr. Chair, at this point, we have contacted everyone who has pre-registered to speak at this morning's public hearing, and we have reached the end of our list.
All right, and we have a couple of people this afternoon.
That's correct. Yes, sir.
Okay, thank you very much, Mr. Bachman. It's my understanding there is an outstanding motion that needs to be heard. Now would be a good time. Mr. Willoughby, while they're handing that out, I said co-op. I meant corporation as far as North Carolina. Okay. Well, I will make sure everybody understands. Thank you. Mr. Treywick.
Thank you, Mr. Chairman, and may it please the commission. I'll be arguing this motion on behalf of the joint applicants, but certainly invite my able colleagues to weigh in at the end should they feel the need to. First of all, we're really excited to come before you today and show why the commission should approve the Anderson CC project under the Siting Act. And we certainly understand our friends on the other side feel very strongly about air quality issues. So do we. Air quality is important to us too. By making this motion, we're not burying those concerns or causing them to echo into a void. Instead, we're simply saying this is not the appropriate forum in which to litigate the merits of an air permit application. And we're respectfully asking the commission to recognize the lines that the General Assembly has drawn between its jurisdiction and that of the Department of Environmental Services over air permits. So before diving in, I think it's important for us to start with the Energy Security Act. The General Assembly made the following findings in Section 5837.110A. Given the importance of sufficient, reliable, safe, and economical energy to the health, safety, and welfare, or well-being, I should say, of the citizens of South Carolina and to the state's economic development and prosperity, the General Assembly finds that the prompt siting, permitting, and completion of energy infrastructure projects are crucial to the welfare of the state. To be sure, the Commission has jurisdiction and a duty to determine the probable environmental impact of a project in a Siting Act case. We readily acknowledge and appreciate that. But the question here is whether it's appropriate to litigate the merits of an air permit application. And respectfully, the answer to that question is no. In determining whether the General Assembly has given another entity exclusive jurisdiction, the Commission must look to the relevant statute. It's from Gant v. Self quoting Rainey v. Haley. The relevant statute here, South Carolina Code Annotated 48-120, says DES shall have authority to abate, control, and prevent pollution. As part of that charge, DES has promulgated regulations, and it's done so specifically with respect to air quality. DES also issues and enforces permits under the authority of the Clean Air Act, South Carolina Pollution Control Act, and the South Carolina Regulation 61-62 titled Air Pollution Control Regulations and Standards. We also provided a copy of the DES Bureau of Air Quality's permitting process as Exhibit 1 to our motion to strike. So how do we reconcile all this? It's really a simple exercise in statutory construction. Under the canons, we must read the statutes together to produce a single harmonious result that gives effect to legislative intent. And we believe our reading does just that. The commission must determine, quote, the nature of the probable environmental impact, whether, quote, that impact of the facility upon, not that, whether that, quote, impact of the facility upon the environment is justified considering the state of available technology and the nature and economics of the various alternatives and other pertinent considerations, and, importantly, find there is reasonable assurance that the proposed facility will conform to applicable state and local laws and regulation. But state agencies shall continue to have authority to enforce compliance with applicable state statutes, rules, regulations, or standards promulgated within their authority. That's from 5833-410. And the commission must, quote, render a decision upon such conditions as determined by the applicable state agency having jurisdiction or authority under statutes, rules, regulations, or standards promulgated thereunder, and the conditions shall become part of the certificate. As ORS witness Bickley testified in this proceeding, DES said it had no concerns or comments. The commission has previously discussed the many environmental agencies that may also touch on various aspects of a major utility facility project. That came in the ACDC docket. We provided a chart of that in our brief of the various state and federal and local entities. That recognition, coupled with the exception in section 5833-410 and the limitation in section 5833-160 subsection 1, underscores that those agencies do not lose jurisdiction over the issues within their purview. Under section 5833-161E, we therefore just have to provide reasonable assurance we will comply with DES's substantive legal and permitting process requirements. And our witnesses have done that. We need not prove the air permit will get approved just to clear the threshold in this Siting Act proceeding. If the General Assembly wanted to jettison DES and have all permitting issues decided here, it would have done so in the Energy Security Act. It did not. Now, instead of wrestling with this analysis, my friends cite to an order from 2002. And at first blush, that may have some appeal. But as we demonstrated in reply, it really cannot withstand even the most minimal scrutiny in light of the significant changes that have taken place since then. Think for a moment about where you were in 2002. I was in middle school. A lot has changed in the utility regulation space since then, not the least of which Act 175 of 2004 that divvied up the responsibilities of the Public Service Commission and created the Office of Regulatory Staff. Case law developed on administrative due process and the requirements for detailed orders. And the Energy Security Act has ushered in a new era for siting generation resources to facilitate the state's economic development. With respect, Order Number 2002-120 and 377 are not binding and cannot bear the weight my friends place upon them. It's of course settled law that a case cannot be considered as binding precedent on a legal point that was not argued in the case and not mentioned in the opinion. That's from Hutto. And for my history buffs, I even cited an 1821 opinion from Chief Justice Marshall in Cohens v. Virginia reinforcing this principle. In the Greenville County Power case, the agency authority question didn't arise until the petition for rehearing. Denying the petition, the commission engaged respectfully in a conclusory analysis that did not cite the Siting Act provisions invoked in the joint applicant's motion here. Elsewhere, though, the commission confirmed that the criterion in controversy there was subsection 5833-161C. Yet that's not the only one at issue here. In this case, by contrast, we've raised 3 criteria, as well as 2 other statutes that expressly preserve the jurisdiction of other state agencies that the commission must read together to decide this case. The 2002 orders address none of that. Neither does my colleague's response in opposition. Importantly, they also do not address the DES statute triggering the jurisdictional question that we have to look at under Gamp Self. When our Supreme Court's previously passed upon the merits of an action, but the question of jurisdiction did not arise, the court found the prior case could not be considered as or construed as implying that it had jurisdiction or of any persuasive authority on the jurisdictional question. So too here. At any rate, the 2002 orders do not and could not account for the Energy Security Act. The General Assembly, however, recently expedited the permitting process for Siting Act projects in Act 41, reflecting its recognition that Siting Act and permitting cases necessarily run on different paths with different timelines. It's kind of a chicken and egg situation, right? Which one comes first? But given that the purpose behind the Energy Security Act was to cut unnecessary red tape and expedite the siting of generation resources to facilitate economic development while preserving parties' ability to participate, it would be a strange day indeed if the Commission nevertheless found that we were required to litigate an air permit twice. Fortunately, the joint applicants provided the Commission with a landing spot on this question. Simply condition the certificate on the company and the joint applicants obtaining all necessary permits like the Commission normally does. You've done it for us, for Santee Cooper, and for Dominion, even as recently as October 10th of 2025, in order number 2025-644. Conditioning the certificate on our successfully obtaining all necessary permits and specifically from the DES Bureau of Air Quality honors various agencies' respective jurisdiction, promotes judicial economy, harmonizes the related statutory schemes. It's exciting, I know. And faithfully applies the canons of statutory construction instead of relying on a conclusory analysis from an order that's 24 years old. The Commission's regs direct it to control the reception of evidence so as to confine it to, quote, the issues in the hearing. Irrelevant, immaterial, or unduly repetitious evidence shall be excluded, and the South Carolina rules of evidence are followed. So we look at Rule 403, which provides that although relevant, evidence may be excluded if its probative value is substantially outweighed by a number of factors. My friends omit key portions of that balancing test in their response in opposition. But when you review it as a whole, we respectfully submit that the Commission should grant our motion to strike because the probative value, if any, of Mr. Lloyd's testimony may offer on the draft air permit application is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the Commission, or by considerations of undue delay, waste, or needless presentation of cumulative evidence to multiple state agencies. One final thing I'll hit on very briefly. We also have a practical justiciability problem. The air permit's not yet ripe. As DEC noted throughout the docket, this was merely an initial transmittal intended to facilitate DES's review of the project and give the company feedback before we submitted a final submittal in the near future. Given that the federal standards for air quality from the EPA have been in flux, if the Commission were to adopt Mr. Lloyd's recommendations without the legislatively conferred authority and expertise of the DES Bureau of Air Quality, it could inadvertently create obligations that are out of step with state and federal law on air quality. But that's just getting the cart before the horse. Because the air permit application is not yet final, it is not appropriate to rule on the critiques of the company's initial analyses and the draft application at this time. In sum, we share and care about the concerns, or not share, we can care about the concerns that SCLC raised. They're important, but they have a path to get those concerns addressed by the agency with expertise on air quality. We don't think the Commission has authority to require those conditions here in a Siting Act proceeding. Now, Mr. Chairman, I recognize the procedural posture we're in here now, certainly not before the hearing, and everybody's here ready to testify. Company has no objection to you taking this under advisement and ruling in the final order, and we'll suspect that might be the case anyway, but thought I'd offer that, and we'll just be sure to renew our objection when Mr. Lloyd testifies. But happy to answer any questions the Commission might have.
Thank you very much. Before we go further, just for the record, since we mentioned Department of Environmental Services, and they are a statutory party, I want to double check to see if any of these statutory parties are online. South Carolina Department of Environmental Services, nobody from the Department of Natural Resources, or Parks, Recreation, Tourism. Thank you all very much. All right, any questions at this time for?
Thank you, Mr. Chairman. Good morning, Mr. Trewick. Sorry, I drew a blank right there. You've made a lot to do about the citation to the 2002 orders. You familiar with the case of, I think it's Campson versus 330 Concord Street? Talks about stare decisis of administrative agencies.
Sure, I'm familiar with the concept, and there's no such thing for administrative agencies.
Well, except you have to have a good reason to deviate from.
Sure.
Okay.
We respectfully believe we've provided plenty of those
Okay.
given the changes in law since that time.
Thank you.
Thank you.
Thank you, Commissioner Belser. Any further commissioner questions? Mr. Vice Chair Williams.
I just want to thank Mr. Trawick for reminding me where I was in 2002.
Happy to, Mr. Vice Chair.
Well, I was out of high school. I don't know if he was or not. Thank you, Mr. Trawick. Let's hear from any other parties. Does anything from the North Carolina Electric Membership Corporation?
Mr. Chairman, we join in the arguments that are made by Duke, but we have nothing further to add.
All right, thank you, Mr. Willoughby. Central Electric Power Cooperative.
Chair Powers, for Central, same. We fully join in Mr. Trawick and Duke's argument. We have nothing to add to it. Thank you.
Thank you, Mr. Walsh. Carolina Coastal Conservation League, Upstate Forever, Vote Solar. Ms. Mixon, the floor is yours.
Thank you, Chair Powers, members of the Commission. I'm Kate Mixon, again, on behalf of CCL, Upstate Forever, and Vote Solar. On behalf of those organizations, we respectfully ask that you deny the company's motion to strike portions of Witness Lloyd's direct testimony. To begin, joint applicants' primary argument is that the concerns raised by Witness Lloyd in portions of his direct testimony, specifically those that are related to the facility's draft air permit application and the associated analysis, are improper for this CPCN proceeding because air permits are within the jurisdiction of the Department of Environmental Services. In our view, that argument is contrary to the plain language of the Siting Act, which under Section 5833-161E requires the Commission to make its own independent finding that it has reasonable assurance that a facility will comply with applicable state and local requirements, including those related to air permitting issues. It would not be possible to determine whether an applicant met that standard unless the Commission was entitled to allow relevant evidence into the record related to the other requirements that the facility would have to obtain. In their motion to strike, the applicants argue that they have provided sufficient information in this case. But that is a factual and legal finding or conclusion that the Commission must make based on the evidence in the record. And to make that determination, the Commission should allow in relevant evidence, including evidence that may run counter to the utility's position on that issue. The purpose of Mr. Lloyd's testimony on these issues are in part to provide evidence about whether joint applicants have met that standard. Again, they may disagree with us and the Commission ultimately may as well, but that's not a reason to strike the testimony from the record. That gets to the ultimate weight that the Commission gives the evidence, not its admissibility. We've heard it from Duke a few times that they would have to prove that the air permit would be approved in this case if this evidence were allowed into the record. And that's not the case. We're asking the Commission to consider the evidence that's presented in light of its own duties under the Siting Act. As we noted in our opposition to the motion to strike, air permitting issues have in fact been a significant focus in past CPCN proceedings. There's been discussion of the 2002 orders. In that case, the Commission denied a certificate on the basis of its concerns that a plant would not comply with the Clean Air Act. And in that case, the Commission found that despite testimony from the power company about its upcoming application for an air permit, that it did not have full and complete information needed to assess the effect of the proposed plant on air quality. and thus could not determine whether the impact of the facility on that portion of the environment was justified. In that case, the power company, in fact, had provided quite detailed information about their upcoming air permit application, including filing testimony about their best available control technology or BACT analysis, and the air dispersion modeling that they conducted for the plant. Witness Lloyd's testimony here raises similar issues, namely his concerns that Duke's air dispersion modeling and BACT analysis were flawed, and that the company's cherry picking of air monitoring data could put the plant at risk of violating NAAQS standards. The joint applicants claim in their reply that our argument against striking Witness Lloyd's testimony relies entirely on these two orders. And to be clear, that's again not the case. We think that the Commission's authority to consider these issues is based in the Siting Act itself. But the orders are illustrative of the fact that testimony about these specific air permitting issues has not only been allowed, but expressly addressed in Siting Act proceedings and Commission decisions in the past. The utilities' reply attempts to undermine those decisions by saying that the orders are outdated and that intervening laws, including the Energy Security Act, render those decisions immaterial. But what they failed to note is that the applicable language in the Siting Act was the same in 2002 as it is today. The legislature in Act 41 mandated expedited review of projects. It did not mandate approval of projects. The Commission is still required to make substantially the same factual and legal determinations before issuing a certificate, in this case, as it was required to in 2002. Joint applicants also point to the fact that the Commission has simply conditioned certificates on compliance with permits in other Siting Act orders that are more recent, and states that would be the appropriate remedy if the Commission were concerned about a facility's compliance with other permits. Even setting aside that air permitting issues may not have been in dispute in those other proceedings, that's not at all dispositive about whether the Commission should strike the testimony or not. The Commission could again decide to issue a similar order in this case, even with the evidence admitted into the record. But that's not something that they must do. And in fact, establishing that as the standard would divest the Commission of much of its express authority under the Siting Act. Rather, the Commission should allow in relevant evidence, and it can determine its appropriate weight when making its decision on the certificate. Further, even if the Commission did not have statutory authority to consider whether a facility would be in compliance with these other state requirements, it is still improper to strike Witness Lloyd's testimony because it is relevant evidence of the nature of the environmental impact of the facility. Whether that impact is justified in light of the need for the facility, and whether the facility will serve the interests of system economy and reliability, considering various alternatives that are available pursuant to Section 5833, 161, C and D. Witness Lloyd's testimony relates directly to the amount of air pollution from the facility, specifically whether the companies have taken steps to properly quantify what that impact will be through his testimony on the air dispersion modeling, and how they will control it through his testimony on the BACT analysis. The company's draft air permit application is the most current, and in fact, to date, the only detailed information that is available to characterize the air pollution impacts from the facility. Again, the fact that his testimony is based on the draft air permit, that goes to the weight, not the admissibility of the evidence. Even though DES has jurisdiction over the air permit, the Commission still has an independent duty to consider the environmental impact from the facility, including air pollution impacts, and determine whether those impacts are justified in light of the need for the facility. Again, it's unclear how the commission could independently make that determination on these issues if they simply struck evidence from parties other than the utility that gets at those very questions. Further, taking applicants' argument to its logical conclusion, it's difficult to understand how environmental nonprofits or other interested parties could raise issues about any number of environmental issues that overlap with other permitting schemes. For instance, endangered species related issues, water withdrawal or discharge permit concerns, stormwater management concerns, or wetlands impacts. All of these are the subject of other permitting schemes that are under the jurisdiction of other agencies. Yet, concerns about facilities' compliance with those requirements have certainly been raised in recent Siting Act proceedings. For instance, the Wassamasaw to Indian Field transmission line case involving Beidler Forest. The applicants claim that it would be unduly prejudicial for them to respond to these issues as part of this proceeding. But they have provided no evidence for how it would be unduly prejudicial or burdensome for them to justify or defend their own air modeling or their own backed analysis. Again, it does not necessarily require that they prove that the air permit would ultimately be accepted, but they could respond to, again, justify that analysis in light of the requirements under the Siting Act. And as we note in our testimony in response to applicant's motion, these issues are also highly important given that the site the joint applicants have chosen is in one of the most highly air polluted areas of the state. Their counsel will have the opportunity to cross-examine our witness, to defend their own analysis to the commission, and to explain why, in their view, the environmental impacts from the facility are justified. Providing an explanation about the nature of the environmental impact of the facility, including its air pollution impacts, and why those impacts are justified, is part of the utility's burden of proof in this proceeding. For those reasons, we don't believe that it is appropriate to strike witness Lloyd's testimony on the air permitting issues and would ask the commission to allow the evidence into the record, at which point the commission can give it the weight that it deems appropriate. At minimum, as we explain on pages 11 and 12 of our response to Duke's motion, we would ask that the commission limit the testimony that is struck from the record if they do decide to grant the motion to strike to only those portions related to witness Lloyd's recommendations, specific recommendations related to pre-construction monitoring, setting more stringent emission limits as a condition on the certificate, or limiting the facility's use of fuel oil. Thank you for your time, and I'm happy to answer any questions.
Any questions for Ms. Mixon?
Mr. Chair.
Vice Chair.
Ms. Mixon, I'm sorry, I couldn't hear your last couple of sentences.
Sure. Happy to repeat them. On pages 11 and 12 of our response to Duke's motion, we noted that in our view, Duke's motion was overly broad and sought to strike portions of testimony that we think are very clearly within the scope of the commission's authority. There are a couple of recommendations that witness Lloyd made that relate to requiring that Duke conduct pre-construction monitoring, recommending that the commission set as a condition on the certificate more stringent emission limits for the facility, or limiting the facility's use of fuel oil. And if the commission does decide that any portion of the testimony should be struck from the record, we think that those are the ones that most directly relate to DES's jurisdiction here, and the additional portions that Duke has sought to strike very clearly, in our view, fall within the commission's jurisdiction and should remain in the record.
Thank you. I'm sorry for asking you to repeat yourself, but I heard you that time. Thank you.
Thank you, Mr. Vice Chair. Any further questions? All right. Thank you, Ms. Mixon. Anything from the Office of Regulatory Staff?
ORS has no position as to the joint applicant's motion.
All right. Mr. Trawick, under Rule 43, you have a right to respond.
Very briefly, Mr. Chairman, and again, appreciate the Commission's time to hear this. I want to start with my distinguished colleague's assertion that we didn't prove prejudice. On page 10 of our reply, the company and the joint applicant said that filing rebuttal testimony, serving discovery, and cross-examining Lloyd at the hearing, and hiring subject matter experts to provide testimony, or lawyers with environmental expertise, all of that is very real prejudice, and it's unduly so in our view, because we just shouldn't have to fight the same battle in two rings. So that's on page 10 of our reply. I believe we're in agreement on the reasonable assurance inquiry, right? And I think that's where the Commission should land here. Air quality is relevant, and look, we didn't make this motion lightly, but this isn't just a discussion of air quality. It's literally trying to litigate what the draft air permit application says, and with all due respect, that's for DES to decide. I really appreciate my friend's concession at the end there that, if you strike anything, it should be the recommendations. I mean, those are the most problematic, right? They're asking the Commission to weigh in on what standards are appropriate, air monitoring, pre-construction air monitoring, and things that are really sort of outside the ken of this Commission and more appropriate for the Bureau of Air Quality. I also want to kind of recenter the focus here on the words because they matter. It's the nature of the probable environmental impact. That's not a final determination on the merits of environmental issues, right? It's something less than that. And you're looking at environmental compatibility. That's the name of the certificate, right? Whether it fits in this area. And for all the reasons our witnesses will explain here today, this very much fits the bill. Thank you, Mr. Chairman.
Thank you, Mr. Trawick. Anything further from anyone else? Since I have your permission, Mr. Trawick, I am going to take it under advisement. We may deal with it later today or may deal with it in the order. Certainly this Commission has the ability to decipher and decide what is important and what isn't. Thank you very much.
Thank you, Mr. Chairman.
All right. You now can proceed. I don't know which witnesses you're going to do first.
Thank you, Mr. Chair. If it pleases the Commission, we'll do a brief opening first before we call our first witnesses.
However you want to do it, Mr. Wellman.
Thank you, sir.
There's musical chairs over there.
Yeah, it's a obstacle course to walk over here. Good morning, Chair Powers, Vice Chair Williams, members of the Commission. We're pleased to be here this morning to present our request for a Siting Act certificate for the Anderson County Combined Cycle. The Anderson CC is a crucial part of the company's all-of-the-above energy strategy to reliably serve South Carolina customers. We're excited to be here today and look forward to answering your questions about the project. No party has argued in pre-filed testimony that the Commission should not issue this certificate. There have been conditions requested on the certificate, and in our testimony, we've indicated which of those conditions we are amenable to. We're encouraged that no party disputes the need for the facility or that the facility will serve the interests of system economy and reliability. As witness Nathan Bass will testify, the project is expected to have minimal environmental impacts, if any. And multiple witnesses will also confirm that the project will conform to applicable state and local laws and regulations. As you heard from my co-counsel just a few moments ago, the only matter in dispute is the particulars of an air permit application that the Department of Environmental Services has the exclusive jurisdiction to decide. Rest assured that the environmental interveners will have an opportunity to raise their concerns through the DES Bureau of Air Quality's permitting process. New dispatchable generation resources such as this one are critical to the company's ability to balance the supply of and demand for electricity and to maintain reliable system operations as we experience significant load growth in our service territory as new people and businesses locate to the state. We're excited to meet the challenge and the opportunity of continued growth in South Carolina as enabled by the passage of the Energy Security Act. For these reasons, we look forward to presenting our case supporting the Commission's approval of this project. Thank you.
Thank you very much. Any response to that? Mr. Welborn, call your first witnesses.
Thank you, Mr. Chair. And before I do that, you may notice that our South Carolina State President, Mr. Tim Pearson, is not in attendance today. He and his appendix send their regrets. Unfortunately, he had an emergency appendectomy yesterday afternoon, and he is in recovery right now. So he would be here. He sends his warm thoughts, but just wanted to make that note for the commission's information.
Before you call your witness, since they've made an opening statement, did anyone else want to make an opening statement? You certainly can. Hearing none.
Thank you, sir. Second, I understand from the other parties that there is no cross-examination for Mr. Sammy Roberts and Lee Mitchell. We have verifications for those witnesses. They're not set to go up until our fourth direct panel. I'll leave it to the commission as to whether you'd like to hear from them or not, but I did want to make that option available in the interest of efficiency.
All right. Thank you.
If those matters being covered, the companies would call to the witness stand Ms. Heather Shirley Smith and Ms. Karen Hall.
Ms. Smith, if you'll raise your right hand. Do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Ms. Hall, if you'll raise your right hand. Do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, Ms. Smith, if you'll turn your microphone on, we'll start with you this morning. Would you please state your name for the record?
Heather Shirley Smith.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy, and I'm the Vice President of Regulatory Affairs and Policy for South Carolina.
I understand that you started practicing utility law in 2002. Is that correct?
That's correct. I started at a law firm in Atlanta. The majority of my practice dealt with utility matters before the Georgia Public Service Commission, rate cases, IRPs, EE, customer complaints, rate disputes, certificates, those kinds of things, fuel cases. And then I was ultimately hired by Duke to do the same type of work in 2011.
Thank you. And you spent many years leading cases for DEC and DEP on a variety of issues before this commission, is that correct?
Yes.
And you've been in your current role as Vice President of Regulatory Affairs and Policy since 2021, is that right?
Yes.
Mr. Chair, based upon Ms. Smith's extensive experience, I would ask that she be qualified this morning as an expert in utility regulatory policy.
All right. Any objection from any party? I think we've done this before. She will be qualified as an expert in regulatory utility policy. Is that correct?
Utility regulatory policy, yes, sir.
Utility regulatory policy. Thank you.
Thank you, sir. Ms. Smith, did you prepare or cause to be prepared 26 pages of direct testimony that were pre-filed with the commission in this proceeding?
Yes, I did.
Do you have any changes or corrections to that testimony at this time?
No.
If I asked you the same questions that were contained within your pre-filed direct testimony this morning, would your answers be the same?
Yes.
Chair Powers, I would ask that Ms. Smith's pre-filed direct testimony filed in this docket be entered into the record as if given orally from the stand.
The pre-filed direct testimony, Ms. Smith, will be entered in the record as if given orally from the stand.
Thank you, sir. Ms. Smith, did you also prepare calls to be prepared to exhibits that were pre-filed with this commission in this docket?
I did.
And do you have any changes to those exhibits at this time?
I do not.
Chair Powers, I would ask that Ms. Smith's pre-filed direct exhibits be entered into the record as the next composite hearing exhibit.
All right. How many are there?
There are two, Mr. Chair.
So it'd be Smith 1 and 2.
Yes, sir.
All right. The pre-filed exhibits of witness Smiths identified as Smith direct exhibits 1 and 2 are marked for identification will be placed in the record as exhibit number 4.
Thank you, sir. Ms. Smith, would you please provide a summary of your direct testimony at this time?
Sure. Good morning, Chairman Powers, Vice Chair Williams, and members of the commission. In my direct testimony, I note that South Carolina needs more electricity. The Anderson County CC is consistent with the plans included in the company's Integrated Resource Plan, or IRP, approved by the Commission in 2024 and is consistent with the more recent 2025 modeling as well. I explained that the Anderson County CC is a part of the company's all-of-the-above energy strategy to power the future for South Carolina. This all-of-the-above energy strategy includes not only natural gas generation, but also renewables, storage, energy efficiency, maximizing current resources, and long-term planning for the evaluation of new nuclear. As a part of that diverse resource mix, new dispatchable generation resources, such as the proposed Anderson County CC, are critical to the company's ability to maintain reliable system operations as new people and new businesses locate to this state, and as families and businesses expand here. My testimony explains that the Anderson County CC is the right resource at the right time at the right site. The site selected for the Anderson County CC is close to existing natural gas supply and transportation, with access to rails, roads, and transmission, and is located in a predominantly industrial area. And we have testimony from an expert, Mr. Nathan Bass, demonstrating that it is environmentally compatible with the surrounding area. I explained that we have engaged and will continue to engage with the local community and leaders and have received a positive response. Further, I testify that construction and operation of the facility will bring enormous financial benefit to the local area and the state in the form of thousands of jobs and millions of dollars in annual property tax revenue, thereby supporting schools and services in the state, which is exactly the kind of investment that economic developers all across the state are working to bring to South Carolina every year. I also testify about the success those developers have had. We are seeing continued growth in the Carolinas, and South Carolina continues to attract new residents and businesses, as noted by the governor and acknowledged by the General Assembly in the passage of the Energy Security Act last year. That act, also known as Act 41, is replete with references to our growing state and the energy necessary to power it. In fact, Act 41 specifically encourages the company to evaluate constructing this type of facility in its service territory serving South Carolina. And I explained that the company's plans for the Anderson County CC are consistent with that encouragement, as well as the other core tenets of the Act. In sum, my direct testimony explains that the public convenience and necessity is well served by this facility, and that it is worthy, we believe, of Commission approval. That concludes my summary.
Thank you, Ms. Smith. Good morning, Ms. Hall.
Good morning.
Would you please state your name for the record?
Karen Hall.
By whom are you employed and in what capacity?
I'm employed by Duke Energy as a Director of IRP Regulatory and Policy Strategy.
Did you prepare or cause to be prepared 22 pages of direct testimony that were pre-filed with this commission?
Yes.
If I asked you the same questions that were contained within your pre-filed direct testimony this morning, would your answers be the same?
Yes.
Chair Powers, I would ask that Ms. Hall's pre-filed direct testimony be entered into the record as if given orally from the stand.
The pre-filed direct testimony, Ms. Hall, will be entered in records if given orally from the stand.
Thank you. Ms. Hall, did you also prepare or cause to be prepared one exhibit that was pre-filed with your direct testimony?
Yes, I did.
Do you have any changes to that exhibit at this time?
No.
Chair Powers, I would ask that Ms. Hall's pre-filed direct exhibit be entered into the record as the next hearing exhibit.
The pre-filed exhibit of witness Hall, identified as Hall Exhibit 1, is marked for identification and placed in the record as Exhibit Number 5.
Thank you, sir. Ms. Hall, would you please provide a summary to the commission of your testimony at this time?
Yes. Good morning, Chairman Powers, Vice Chair Williams, members of the commission. My direct testimony explains that the Anderson County CC facility is a critical new generation source that we need to help meet significant growth in energy and capacity needs of our current and future customers in Duke Energy Carolina's service territory. I explain that the need for the facility is well established and that since 2023, the need for the Anderson County CC facility has been consistently confirmed by Duke Energy Carolinas and Duke Energy Progress, which I will refer to together as the companies, comprehensive integrated resource planning or IRP process. My testimony explains that as part of the resource planning process, the companies compared the Anderson County CC to other generation options in terms of cost, reliability, resource availability or schedule constraints, fuel cost and availability, transmission constraints and costs, ancillary services capabilities, and environmental costs and restrictions, and that the Anderson County CC was overwhelmingly selected as a critical component of meeting the current and future needs of South Carolina customers. I note in my testimony that the Commission recently reviewed and approved the company's 2023 IRP, inclusive of the 2023 IRP's proposed near-term action plan. Specifically, the Commission approved the steps set forth in the near-term action plan as reasonable and appropriate steps for the companies to take at this time to make progress on meeting the resource needs of South Carolina customers. The near-term action plan identified the need for 5 new combined cycle generating facilities to meet the growing demand of the system, including one of those facilities located in South Carolina to achieve commercial operation by 2031. My testimony explains that the Anderson County CC is the third of these 5 needed facilities. My testimony also explains that the Anderson County CC was compared to other generation options as part of the updated modeling the companies performed in 2025 and in more than 40 portfolios evaluating a range of planning assumptions. The need for the Anderson County CC was confirmed. In short, my testimony explains that the company's resource planning process confirms that the Anderson County CC was compared to other generation options in the Commission-approved 2023 IRP and in the modeling performed in 2025, and that the modeling overwhelmingly confirmed the need for this facility by 2031 for the company to reliably meet growing energy and resource needs. This concludes the summary of my direct testimony.
Thank you, Ms. Hall. Mr. Chair, these witnesses are available for questions.
Thank you very much. We'll start with North Carolina Membership Corporation.
We have no questions.
All right, Central Electric Power.
Likewise, we have no questions.
All right. Ms. Mixon, any questions?
No questions at this time.
All right.
Thank you.
Office of Regulatory Staff.
No questions, Chair Powers.
Any commissioner questions? Commissioner Belser.
Thank you. Good morning.
Good morning.
Appreciate your
Good morning.
testimony this morning. I think this may be more from Ms. Hall, but Ms. Smith, if you feel comfortable, I just want to get out there. I know, Ms. Hall, you had in your testimony about the ownership percentages from the North Carolina Membership Corporation and Central Electric, and could you just tell us about that briefly?
Yes. So let me just take a moment and get there. So from a resource planning perspective, we do not believe that the joint ownership with NCEMC or with Central impacts the need for the Anderson County combined cycle. We have joint ownership with our W.S. Lee plant on our system as well here also in Anderson County. And so when we're planning for our total systems need, and we don't believe that the joint ownership with NCEMC or Central, who are wholesale customers of Duke Energy, would impact the need for the facility.
Okay, I'm really just wondering if you could tell me about the percentages and the amount, because I don't know that don't seem to be very large amounts.
NCEMC will own 100 megawatts of the facility's capacity, and Central would own 95 megawatts of the system.
And it's
of
a
the capacity.
1365 total.
Thank you very
Yes.
much. Thank you.
No problem.
Thank you, Commissioner Belser. Commissioner Caston.
Thank you. Good morning.
Good morning.
Relative to the South Carolina Department of Environmental Services, and I guess the Bureau of Air Quality would be one, but there's also the water and wastewater and such. For South Carolina's agency, the Department of Environmental Services, have they not been designated by the EPA as the statutory agency for air quality permits, water, wastewater, and such?
Yes, Commissioner.
And thinking back to, I guess, the earlier arguments relative to 5833, 160, and I think B, C, E, and different things were mentioned. And you're probably not the one, whoever might be the best to answer this, if possible. You know, as designed, as the proposed design is, will the proposed facility meet those federal and state air quality, water quality requirements?
Yes, we believe so. I will say there are some changes going on at the federal level as it pertains to emissions, and we have high confidence that we'll be able to meet those standards. And so, and we, we'll be filing our permits in the coming months. And so, when I think about this issue, I think about Act 41 and the expedited air permit timing that DES has now. It was shrunk to 6 months for the reasons that Mr. Trawick mentioned. And so we wanted to go ahead and get the conversation started in transparency. We went ahead and filed a draft application knowing that we have these other regulations that will need to update the application and finalize. That clock doesn't start ticking till that application is finalized. And so so that is what is before DES in an effort for transparency for us, so that we could share where we were and begin that journey, especially given DES's expedited timeframe.
Thank you. No more questions. Thank you.
Thank you, Commissioner Caston. Commissioner Williams.
Thank you, Chair Powers. Good morning.
Good morning.
My questions are probably for Ms. Smith. You talked about community engagement, and I think at the night of the customer public hearing, Mr. Welborn mentioned an event that was planned probably when there was a winter weather storm. Were you able to hold that event in the intervening time?
We were, and it was February 16th. And we had a date in this hearing room, February 17th. So I was in Columbia February 16th, but we have a number of folks who were at that February 16th event, including Alicia Dash, who will be up soon to provide her testimony. But we were able to quickly get that rescheduled. We knew it was important to people. When we were at the public hearing on February 2nd, I believe it was February 2nd, it was clear that there were customers and interested folks who would like to have more conversations with us, and so we were able to reschedule that event for February 16th.
Would you generally kind of categorize that, given what we heard at the customer public hearing and what we heard this morning, could you generally respond to what we've been hearing and how that was addressed at your February 15th public hearing, if that was the date, customer open house?
Sure, and I will note, I will defer. I'm familiar with some of the issues, and not even issues. I'm familiar with some of the conversations, but Ms. Dash will be in a better place to describe that. But I also think of this as a continuum. We've been talking to local leaders and the community in a variety of ways for a long time, and so we know that there are a variety of questions. So a lot of what we've been dealing with is answering questions, and I believe in many cases we've been able to answer those questions to the questioner's satisfaction. We do know that the local area is worried and concerned about things like air and traffic and noise and all the things that anyone would be concerned about with major development coming to an area. And so it really underscores to us the importance of us continuing to engage with the community, particularly as we go through the construction process and further design elements if approved by the commission. Our engagement does not end the day after this hearing, and our engagement does not end the day after the commission if the commission chooses to issue a certificate. We have a long history of being good neighbors in our plants in the upstate, and our plants in particular in the upstate, because I'm an upstate girl. But we're very proud of the interaction and the support that we have and give to the local community. So we, I believe, have demonstrated that we will be in a position to comply with local ordinances, permits, and that kind of thing. And, you know, we still have steps there. This is the first of many steps. This is the thing that gets us out of the gate. But it's by no means the last thing that happens. If we don't get those permits, then we can't proceed. So it's a continuum of those conversations, as well as different steps we'll take along the way while those conversations are going on.
I'll ask this question, Ms. Dash, but was there anything that you've learned in the community workshops, open houses, customer hearings that we've had that you've been able to respond to and address either through design or through processes?
Yeah, I'll leave that to Ms. Dash and maybe also Mr. Bobby Smith. But we remain mindful of some of those concerns, as well as with traffic and signage and understanding more about noise and the importance of being within the ordinance of the surrounding area. So I will leave some of those questions to them. They'll be in a better position to answer them. I will say, from the chair that I sit in, I've seen a lot of responses. I know that we have worked very hard under Ms. Dash's leadership to be responsive, not just in those rooms where customers come, but in everyday conversation and with neighbors and in a variety of forums.
If I may,
Absolutely.
I also I was able to attend both of those community open houses and had the privilege of having the first table as our attendees were coming through the door and kind of welcoming them past the sign-in. And of course, I covered the need for the facility. And my takeaway from those open houses was that people understood or seemed to understand the need. They had questions about all of the things that Ms. Smith just spoke of, and we directed them to those people. But from a need perspective, the community members that I spoke to understood it, and Ms. Dash can probably speak a bit more to that. But that was my takeaway.
Thank you. I appreciate both of you answering the question and look forward to delving into it a little bit more later on. But thank you very much. No further questions.
Thank you, Commissioner Williams. Any further commissioner questions? Ms. Smith, good morning.
Good morning.
I've just got a couple of things. First, as Commissioner Caston was asking you about emission standards, you talked about expecting a change. Do they meet today's standards?
My understanding is that we could meet today's standards, but if those standards change, we want to make sure that we can meet tomorrow's standards as well, and it may affect the operation of the plant. So I would maybe also share that question with Mr. Bobby Smith.
Okay. Well, the only thing constant in life is change. I think we know that. And this anticipated change, be the devil's advocate for a moment. This anticipated change is a relaxation of restrictions. Is that correct?
I think that's a reasonable expectation.
Okay. But that hasn't happened yet. do you consider relaxing standards as far as pollution? Is that a step backwards for this country?
I think that's why these questions are so hard, and I think that's why when I think of the tough spot that the commission's in with considering impact and justifying the need, I don't think it's really hard to look at one without the other. So whether it's a step back from the country, I'm not sure about that, but I do know it will be a huge step back for the country if we're not able to meet the nation's energy supply and the needs of our customers.
Well, at the same time, I think you just said that if the standards are what they are today, that if you had to, you could meet those.
Yes, I'm a little bit reluctant to go too far down this path because DES hasn't spoken. They have not raised any concerns in this docket, but I wouldn't presume to speak for the commission, and I wouldn't presume to speak for DES. But we have every confidence that we could meet whatever standards are required of the company.
Well, I think what I'm saying is, can we not go beyond the minimum standards in providing services? Or shouldn't we go beyond the minimum standards if we can?
I think that is where being a part of a diverse, all of the above system matters. We're perfectly happy not to run gas plants when the sun is shining, and get that benefit of solar energy and putting downward pressure on fuel prices, needing gas plants less in that moment. But we do need to be able to operate the facilities that we have to the maximum benefit of customers and meeting energy supply. But I would go back to that is why it is so important that we have a diverse resource mix where we can lean on resources like solar, like batteries, like even energy efficiency in some of our demand response programs that help mitigate or lessen the need for operation of the plant at a given moment in dispatch. So every type of resource has a role, and I'm glad that we're pursuing so many different types of resources.
And I agree. I think it's all in at this point. And I know I've asked the question before of different people why nobody really saw all this coming, but I guess a lot of it is that at the present, data centers are not, for one thing, are not regulated, or we don't have any authority. I don't know who does. And following up with Commissioner Williams' questions, we were all at the same public hearing. There was a lot of negativity there, and particularly, could you address it? If I remember correctly, there was some issue about the location of the schools around there. Could you address that one issue?
Sure. I would also encourage you to speak with Ms. Dash later. And so we've had, and I think it was also evident we'd been having conversation with the school district. There was representation of the schools there. But I think that underscores for us why it's so important that we meet the standards that South Carolina sets out for us, and that why it's going to be so important, the importance of that DES permitting process. And I believe that permitting process will give participants in that process, including the public, greater confidence in what's going to be happening in their area.
Okay, well, thank you. And I hope we could reach the highest possible standard, regardless of what changes with the EPA. We all got to live here.
Absolutely.
Thank you, Ms. Smith.
Chair Powell.
Commissioner Caston.
Kind of follow up on that. And I think you answered it. In essence, the company is required to comply with South Carolina law and federal law relative to clean air, water, and such.
Yes.
And to your knowledge, is there, other than the Bureau of Air Quality in South Carolina, is there some other law that would require the company to do anything beyond that?
There are local ordinances. There are ordinances in the area that we would need to comply with. But in terms of building and operating the plant, It is, it's a South Carolina jurisdictional endeavor.
Thank you, ma'am. No more questions.
And Ms. Smith, that's one thing that is addressed that's helpful in Act 41. If there are local ordinances that impair ability, state level would overrule that. Is that correct?
That is correct.
Okay. Thank you very much. Any further commissioner questions? All right. Thank you all very much.
Thank you.
Mr. Chair, I'd ask that these witnesses be excused at this time.
Yes, I know they're coming back for some rebuttal.
Yes, sir.
They're not going anywhere.
Correct.
May take me just a minute to pack up here.
Take your time.
You want me to call the next?
In fact, we've been going for almost an hour and a half. Let's take a 10-minute break now and before we proceed, if we could. We're in recess until 11:30. Good morning again. We are back on the record on docket number 2025-250E, the Anderson Siting Act proceeding. We are ready for more witnesses from the company. Mr. Cooper.
Thank you very much, Mr. Chairman. Just for the sake of the court reporter, I'm Ashley Cooper on behalf of Duke Energy. At this time, the company calls to the stand Bobby Smith and Nathan Bass.
Mr. Smith, if you'll raise your right hand. Do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Mr. Bass, do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right. Mr. Smith, whenever you're ready. Okay. And make sure that's turned on, please, sir, but you'll see a red light. There you go. Perfect. Mr. Smith, please state your name and business address for the record.
My name is John Robert Smith, Jr. I typically go by Bobby. My business address is 525 South Tryon Street in Charlotte, North Carolina, 28202.
And by whom are you employed in what capacity?
I am employed by Duke Energy Business Services, LLC, as the General Manager of New Gas Generation Development within the Project Management and Construction Department of Duke Energy.
Did you prepare or cause to be prepared under your supervision direct testimony consisting of 21 pages that was previously filed publicly and confidentially with the Commission on October 30th, 2025 in this docket?
Yes.
Do you have any changes or additions to your pre-filed direct testimony?
No.
And if I asked you the same questions here today, would your answers be the same?
Yes.
Did you pre-file any exhibits in conjunction with your direct testimony?
No.
Chairman Powers, at this time, I move that Mr. Smith's pre-filed direct testimony be entered into the record as if given orally from the stand while maintaining the confidentiality of the portions of Mr. Smith's testimony that were pre-filed under seal in this docket.
Thank you. The pre-filed direct testimony of Mr. Smith be entered in the record as if given orally from the stand. Confidential portions of that testimony shall remain under seal and confidential unless or until the Commission rules that such information is not entitled to protection from public disclosure, or if the requesting party agrees that such information is no longer confidential or proprietary.
Thank you, Mr. Chairman. I won't ask you to go back through that one again. Mr. Bass, turning to you, sir, please state your name in business address for the record.
Nathan V. Bass. My business address is 1800 Innovation Point, Suite T 200, Fort Mill, South Carolina, 29715.
And by whom are you employed in what capacity?
I'm employed by United Grid Solutions, LLC, a subsidiary of Pike Corporation, as Director of the Facilities Planning and Siting and Transmission Line Engineering Divisions. United Grid Solutions, LLC provides electrical transmission and substation siting, permitting, engineering, procurement, and project management services to electrical utility clients throughout the United States.
Thank you, Mr. Bass. And Mr. Bass, before turning to your direct testimony, I want to ask you a few more questions about your qualifications. How long have you worked in the utility industry?
I have 15 years of experience in the planning and development of various landscape architectural and regional planning projects, including the planning and development of utility facilities.
And what is your educational background?
I hold a bachelor's degree in horticultural science with a concentration in landscape design and a master's degree in landscape architecture from North Carolina State University.
And please briefly list prior South Carolina siting dockets you have been engaged.
I have testified before the Commission in numerous Siting Act proceedings, most recently in docket numbers 2024-287-E and 2024-286-E.
And have you previously held any roles that are relevant to your testimony today?
Yes, I joined Pike Energy Solutions, LLC as a landscape architect in 2011, and as of January 2025, I now serve United Grid Solutions in my current position as director. My technical background includes site design and development for utility substations, project permitting, regional planning, management of right-of-way acquisition, development of siting and environmental reports, and preparation of viewshed and visual impact analyses from cultural or scenic resources.
Please describe your involvement with the environmental studies and analyses supporting the proposed facilities in this proceeding.
So my team conducted studies, compiled data, and analyzed extensive information regarding environmental, land use, cultural resources, and visual effects that will result from constructing the proposed facilities. Pike conducted several studies to assess the environmental impact of the proposed facilities, which include a jurisdictional waters delineation, which are streams and wetlands, a threatened and endangered species assessment, a cultural resources assessment, and an auditory assessment. My team also gathered various data sets using geographic information system from online resources coupled with field reconnaissance to assess impacts to visual resources, land use, flood, and aviation. Subject matter experts within DEC contributed information regarding air quality, seismological, meteorological, and geological information included within the report.
And can you elaborate on your role as a director and describe further your current responsibilities?
In my role as director of the Facilities Planning and Siting and Transmission Line Engineering Divisions for United Grid Solutions, I oversee work providing electrical transmission and substation siting, environmental due diligence, permitting, and engineering services to electrical utility clients throughout the United States.
Thank you. Mr. Chairman, based on Mr. Bass's extensive experience in matters related to utility, facility siting, and environmental impact evaluation, including his preparation of siting and environmental reports, viewshed visual impact analyses for utility facilities, I propose to tender this witness as an expert in the fields of utility facility siting and environmental compatibility, which would include land use, cultural resources, and visual impacts.
All right, any objection from any party? Hearing none, he'll be qualified as an expert in utility facility siting and
I think in environmental compatibility.
environmental compatibility.
Thank you, Mr. Chairman. And now, Mr. Bass, going back to your direct testimony, did you prepare or cause to be prepared under your supervision direct testimony consisting of 18 pages that was previously filed with the Commission on October 30th, 2025 in this docket?
Yes.
Do you have any changes or additions to your pre-filed direct testimony?
No.
And if I asked you the same questions here today, would your answers be the same?
Yes.
Did you prepare or cause to be prepared under your supervision 2 exhibits? Exhibit 1, your professional resume, and Exhibit 2, the environmental report, which was filed confidentially and publicly, that were previously filed as attachments to your pre-filed direct testimony with the Commission in this docket?
Yes.
Do you have any changes or additions to your exhibits?
No.
Chairman Powers, at this time I move that Mr. Bass's pre-filed direct testimony be entered into the record as if given orally from the stand, and that Mr. Bass's direct exhibits be marked and entered into the record while preserving the confidentiality of those portions of the environmental report that were filed under seal.
The pre-filed direct testimony of Mr. Bass will be entered the record as if given orally from the stand. The pre-filed exhibits of Witness Bass, how many are there?
There were
or it's just his report?
Yeah, that's correct.
Known as the report, the environmental report, will be marked as exhibit number 6. The confidential portions of the exhibit shall remain confidential unless or until the Commission rules that such information is not entitled to protection from public disclosure, or if the requesting party agrees that such information is no longer confidential or proprietary.
Thank you, Mr. Chairman. Mr. Smith, have you prepared a summary of your direct testimony?
Yes.
And Mr. Bass, have you prepared a summary of your direct testimony?
Yes.
Okay. At this time, we'd like to start with Mr. Smith and then proceed to Mr. Bass. Mr. Smith, please provide a summary of your testimony.
Thank you. Good morning, Chairman Powers, Vice Chairman Williams, and members of the Commission. The purpose of my direct testimony is to describe the design, procurement, construction schedule, and current cost estimate for the Anderson County Combined Cycle Generating Plant. The Anderson County CC is designed to meet rapidly growing generation needs in the region as an efficient and flexible hydrogen-capable advanced class CC facility. In fact, the Anderson County CC's efficiency will be among the best within DEC service territory. By incorporating the latest advanced class combustion turbine technology available to the market today, the Anderson County CC will offer enhanced operational flexibility, enabling it to adjust output more rapidly than conventional coal or gas-fired plants, while also delivering lower emissions. This ability to quickly ramp will facilitate the integration of increasing amounts of diverse generation resources into DEC's system. The Anderson County CC will use GE Vernova Model HA.03 combustion turbines in a 2-on-1 combined cycle configuration consisting of 2 combustion turbines, 2 heat recovery steam generators, which we may say HRSG, and 1 steam turbine generator, and it will include bypass stacks that will allow the combustion turbines to operate in simple cycle mode when the steam cycle is out of service. The design incorporates emission controls, including selective catalytic reduction technology located within the heat recovery steam generator equipment. The Anderson County CC will also have dual fuel capability, utilizing on-site ultra low sulfur diesel as an alternate fuel for approximately 3 days of full load on-site storage. And the combustion turbine will also be capable of utilizing a 30% hydrogen blend with natural gas if hydrogen becomes commercially available and economical. Finally, the Anderson CC will use an air-cooled condenser rather than traditional wet cooling, which substantially reduces the water consumption and the discharge. The company's strategy for constructing the proposed facilities includes a combination of owner-procured major equipment components, such as the combustion turbines, step-up and auxiliary transformers, steam turbine generator, and then contracting with a full-service EPC contractor for the engineering, balance of plant procurement, construction, and commissioning. The company will procure the owner-furnished equipment and will then assign it to that selected EPC contractor for integration into the facility for coordination, construction, and commissioning. The proposed facilities are targeted to be placed in service by the end of 2030, with site mobilization and construction beginning in the second quarter of 2027, and substantial completion and commercial operation of the unit in the fourth quarter of 2030, followed by a final completion milestone in the second quarter of 2031. DEC has a long history and legacy of building and operating facilities under its control in a manner that conforms to applicable state and local laws and regulations. DEC is leveraging the same technology at other new generators being added to the company's system, which decreases the company's operating cost by having common operating knowledge and spare parts inventory. The company is deploying proven technology to reliably meet our customer needs in a cost-effective manner. This concludes my direct testimony summary.
Good morning, Chairman Powers, Vice Chairman Williams, and members of the Commission. My purpose of my direct testimony is to discuss the methodology and environmental studies conducted for the Anderson County Combined Cycle Generating Plant, the proposed 230 kV switching station, the fold-in of the existing Chickasaw black and white 230 kV lines, and related facilities in Anderson County, South Carolina, collectively referred to as the proposed facilities. By way of overview, Pike conducted several studies to assess the environmental impact of the proposed facilities, which include a jurisdictional waters delineation, streams and wetlands, a threatened and endangered species assessment, a cultural resources assessment, and an auditory assessment. My team also gathered various data sets using geographic information system from online resources, coupled with field reconnaissance to assess impacts to visual resources, land use, flood, and aviation. Subject matter experts within Duke Energy also contributed to elements of the environmental report, such as climatology, seismology, air quality, among others. Beginning with air quality, Duke Energy began the process of filing its air permit application for the proposed facilities on October 1st, 2025, by submitting its initial transmittal to the Bureau of Air Quality Division of South Carolina Department of Environmental Services. The proposed facilities will be a major stationary source under Title V of the Clean Air Act, which will require a prevention of significant deterioration, also called PSD, permit. As part of the PSD application process, the proposed facilities are required to evaluate best available control technology and perform an air dispersion modeling analysis. Duke Energy has completed much of the analyses and is proceeding through the standard permitting process defined by the EPA at SC DEN as planned. As to water quality, any anticipated environmental impacts of the construction and operation will be minimal and short term. Also, prudent construction and erosion control measures will be used to prevent sedimentation from occurring within sensitive waterways, and disturbed soils will be stabilized with vegetation as construction progresses. With respect to wetlands and streams, Pike performed a delineation of wetlands and other surface waters to identify aquatic features that may be subject to the jurisdiction of the U.S. Army Corps of Engineers. Wetland boundaries and streams were marked and surveyed using the methodology and criteria specified by the Army Corps. Notably, though, preliminary site development plans indicate that no streams or wetlands will be impacted by the proposed facilities. Relatedly, with respect to water use, the proposed Anderson County CC project will be designed and constructed with air-cooled technology to reduce the need for cooling water during operations. These systems rely on ambient air to cool the condensate, reducing the need for large water withdrawals relative to typical water-cooled plants. Turning to protected species, Pike conducted a review of available data sources and a field habitat assessment to document habitats within and around the site to evaluate the potential for protected species to occur within the site and evaluate potential effects. Based on Pike's field review of habitat within the site, 5 protected species have the potential to occur: the tricolored bat, monarch butterfly, the smooth coneflower, eastern black rail, and bald eagle. Pike concluded that the proposed facilities will not jeopardize or affect the existence of any federal or state-listed species. Next, with respect to cultural resources, Pike engaged Brockington and Associates Incorporated, a cultural resource consulting firm with an office in Charleston, South Carolina, to conduct an architectural and archaeological resources investigation. Brockington determined that none of the architectural or archaeological resources are eligible for the National Register. Therefore, the proposed facilities will have no adverse effects to cultural resources. From a visual standpoint, Pike conducted a probable visual effects field study to determine the visual impacts of the proposed facilities. Although the proposed facilities will be constructed on what is mostly open pasture, the surrounding area's industries, utilities, and commercial enterprises dominate the current view. However, the proposed facilities may be visible from only a minor portion of the surrounding area because of the area topography, tree-covered areas, and the many large industrial and commercial buildings in that portion of Anderson County. Pike engaged Stewart Acoustical Consultants to evaluate the potential auditory impacts from the proposed facilities. Stewart evaluated the auditory impacts on the community by quantifying the existing ambient noise levels and comparing them with the noise levels that would be expected by the proposed facilities. Based on its review of the potential auditory impacts, Stewart determined that certain locations in the vicinity of the proposed facilities will have increased sound levels. However, the predicted noise levels are all well below Anderson County's noise limits established within its Code of Ordinances. Finally, construction and operation of the proposed project will require that the company obtain several permits. The permits will contain conditions that the company must follow to ensure compliance with the terms and conditions of each permit. company will develop and implement a site-specific environmental monitoring and compliance program to ensure those conditions are followed during construction and operation. In conclusion, the proposed facilities are appropriately sited within a portion of the county characterized by compatible industrial uses. Transmission interconnections will occur entirely within the project boundaries, eliminating the need for third-party land disturbance. Additionally, preliminary assessments indicate minimal environmental concerns. Given the current state of available technology, the nature of the proposed facilities, and the economic impracticality of alternative locations or configurations, the environmental effects, if any, are considered justified. This concludes my direct testimony summary.
Thank you, Mr. Smith and Mr. Bass. Mr. Chairman, at this time, Mr. Smith and Mr. Bass are available for any questioning by parties and the commission.
All right. Mr. Gooding?
Thank you, Chair Powers and members of the Commission. Good morning, Mr. Bass and Mr. Smith.
Good morning.
Good morning.
My name is Thomas Gooding, and I represent CCL, Upstate Forever, and Vote Solar. I have a few questions for both of you today, but if it's all right, I'd like to start with Mr. Bass. Mr. Bass, first, would you please turn to page 7 of your direct testimony? On lines 1 through 10, you describe the review that you and your team at Pike conducted to assess the environmental impact of the proposed facilities. Is that correct?
That is correct.
And you state that your review included information from DEC's subject matter experts regarding air quality, among other things. Is that correct?
That is correct.
As part of your review, did you review DEC's draft air permit application and its underlying analysis?
I am familiar with their application, yes.
Okay. So given that you're reasonably familiar with that analysis, are you able to answer some questions about it?
Yes.
Okay. Based on your review, your general environmental review, you determined that the construction, and operation of the proposed facilities will conform to applicable federal, state, and local environmental laws. Is that correct?
Correct.
And that includes compliance with laws and regulations related to air quality, correct?
That is correct.
In the environmental report that your team prepared for this case, you included a section on air quality on pages 74 to 75 of that report. Is that right? If you'd like to turn to those pages, you're welcome to.
Okay.
In that section, you note that the South Carolina Department of Environmental Services, or DES, regulates certain criteria air pollutants established by the EPA, right?
Correct.
And you would agree that those criteria pollutants include nitrogen oxides, or NOx, particulate matter, including PM 2.5, and carbon monoxide, among others. Is that right?
Yes.
And you would agree that these pollutants are known to cause adverse health impacts. Is that true?
Based on my understanding.
Okay. Have you reviewed the testimony of CCL et al. Witness David Lloyd?
I have.
Okay. So you are aware that his testimony discussed impacts from PM 2.5, NOx, and ozone. Is that right?
His testimony was very technical in nature, but I'm familiar with some of the items.
Thank you. That is helpful. Do you have any reason to dispute the impacts that he discusses about those air pollutants?
I do not have any reason to dispute or agree with them.
Okay. As you note in the environmental report that you have open, DES has adopted the National Ambient Air Quality Standards established by the EPA to limit emissions of these air pollutants, right?
Correct.
And you explain that if a facility exceeds certain emission rates, it is deemed a major source of pollution and therefore must implement best available control technology, or BACT, and perform air dispersion modeling analysis. Is that right?
Yes.
Okay. And as you noted in your summary just now, you are aware that the Anderson facility is a major source of pollution and therefore must implement BACT and perform air dispersion modeling analysis, right?
Yes.
Okay. With respect to BACT, best available control technology, Mr. Smith, I'd like to turn to you. In your testimony and in your summary, you stated that the company will equip the proposed facility with selective catalytic reduction technology. Is that correct?
That is correct.
And you state that this technology will allow the facility to achieve BACT limits for NOx and CO2 emissions. Is that right?
CO emissions, yes, correct.
And CO emissions, excuse me. Other than your conclusions about NOx and CO emissions, your pre-filed testimony does not state whether the facility's equipment would achieve BACT limits for other criteria pollutants. Is that correct?
Mr. Chairman, I'm going to object to this. I've let these questions go for a little while now, but we're asking detailed questions about permitting issues that we've all established as subject of DES. And so I've let my witnesses answer questions that relate to the basic facts about the plant and things like that that are properly before us. But, asking this witness a detailed question about permitting that's before DES is improper and outside the scope of this hearing. And so I object on the grounds of relevance.
Thank you, Mr. Cooper, but it is cross-examination and we can take it for what it's worth. We just want to stay out of any of the confidential area. Thank you. Overruled.
Thank you, Chair Powers.
So I would say, while my testimony may not address those other issues related to BACT, yes, it is Duke Energy's commitment that this will be a BACT compliant facility.
Okay. And Mr. Smith, did you also review witness Lloyd's pre-filed testimony in this case?
Yes, I've read it.
Okay. So you're reasonably familiar with his analysis?
Correct.
Okay. When you concluded that the proposed facility would achieve BACT limits for NOx, had you compared DEC's BACT limits to those at similar plants in other jurisdictions?
Personally, I have not, but SMEs on our team have reviewed that information.
Okay. Thank you. Did you know that Duke's proposed limits are based on 30-day averaging periods when most emission standards for NOx are based on more stringent, much shorter averaging times between 1 and 24 hours?
I'm going to object to the form of that. I don't know that we've laid a foundation. This is most, but the witness can answer it if he can or if it's within us. I object that there was no foundation laid for this. This is just a testimony that he's concluded that he's making conclusory statements about these other plants. But having said that, if the witness can answer it, I'll allow it.
I'm going to rule the objection, but if we
sure
kind of move on.
Sure. I'm happy to point you to Mr. Lloyd's testimony, if that would be helpful. Do you have his testimony in front of you, Mr. Smith?
I do think so. Hold on 1 second.
And I'm happy to provide it if that's easier.
Yes, I have it.
Okay, would you turn to page 14 for me?
I'm on page 14.
Okay. And would you read lines 14 through 18, please?
Starting at 14 through 18, Mr. Lloyd's response to the question was yes. To begin, Duke Energy's proposed BACT limits for NOx emissions measured in parts per million ppm are based on a 30-day averaging periods. However, most NAAQS standards are based on more stringent, relatively short averaging times between 1 and 24 hours, depending on the pollutant, much shorter than the 30-day averaging period Duke Energy has proposed here. That's the end of line 18. That is what it says. I am aware that Duke is permitting a 30-day averaging period. I can't speak to the comparison to all other permits that he's referring to here.
Okay. But you don't have any reason to dispute that the proposed limits are based on 30-day averaging periods rather than averaging periods of 1 to 24 hours.
Again, I object to the form of this question. I mean, do you have any? He's testified to what he knows. We've not put Mr. Lloyd's testimony on the stand. We've not had any cross-examination of Mr. Lloyd to know the veracity or the basis or the foundation for his conclusions. His counsel is sitting up here acting as though these things are all accepted in asking this witness to comment on the statements and the foundations and the validity of his own expert. He can ask his expert, you can ask his expert, and we can ask his expert. But putting him up here with no chance to establish the basis of his testimony and ask these gentlemen to comment on it is improper, and I object.
Mr. Cooper, I think you're also saying he's pitting one witness against another. Is that correct?
But that would have been very concise, and I wanted to take a little more time, Mr. Chairman.
I kind of thought that's where you're going. Mr. Gooding, I'm going to sustain his objection and ask that you move on to something else.
Okay, will do. If I may, Chair Powers, my intention here, the purpose of these questions is to gain a better understanding of whether joint applicants have shown that there is reasonable assurance that this facility will comply with applicable laws and regulations. That includes upcoming permitting regulations like the air permit requirements. That is a requirement. I'm sorry?
You can ask him that.
Great, thank you, I appreciate it.
And just to be clear, Mr. Chairman, and I gave him some leeway to make some legal arguments there and testify. You can certainly ask them questions about compliance with permits. It's the questioning of these witnesses against one expert's testimony. That's the problem, and it's accepting that is the standard upon which to question them against is the issue.
I took that last one as a clean question that wasn't talking about experts, but rather just his opinion.
Thank you. As a general matter, Mr. Smith, would more stringent emission limits, all other things being equal, mean less air pollution from the facility?
Again, I'm not the environmental expert or the modeling or permitting expert. To me, the averaging period discussed is not going to have an impact to the overall emission. It impacts how the unit is operated and maintained, and the controls around that operational, those operational standards.
Okay. You stated that you are familiar with Mr. Lloyd's testimony. Do you have any reason to dispute that similar facilities to the one proposed here in Alabama, Virginia, and other states are subject to more stringent backed requirements for NOx compared to the proposed limits here?
I have no knowledge or basis of those other permits to render an opinion.
Okay. Are you able to render an opinion based on the testimony that you read from Mr. Lloyd?
Again, I've read what he has stated in his testimony. I can't verify that that is absolutely correct or for the record.
Mr. Gooding, this may be better addressed after we have some other testimony and the rebuttal.
Okay. If it's my understanding, I believe these witnesses will not be appearing for rebuttal. Is that correct?
That's correct. We're not up for rebuttal.
They did not provide any rebuttal testimony, Mr. Chairman.
But I appreciate your patience, and I will keep moving along. Thank you. Let's turn to Mr. Bass again, if you will. Turning now to air dispersion modeling. Mr. Bass, as an initial matter, are you familiar with Mr. Lloyd's pre-filed testimony?
I have read it.
Okay. And you've already confirmed that you have reviewed the draft air permit application, correct?
Yes.
You noted in the environmental report that air dispersion modeling is required to ensure that pollution levels from a proposed facility do not exceed the national ambient air quality standards. Is that right?
Correct.
But Duke's modeling relies on data from existing air monitors 16 or more miles away. Is that correct?
Which is standard.
Okay. And would you agree that for nitrogen oxide and PM2.5, among other pollutants, Duke relied on data from monitors located over 30 miles away?
Duke Energy submitted a protocol for which to conduct the air dispersion modeling to DES. DES subsequently approved that protocol, so that was the process that was incorporated.
Okay. I'd like to refer you to Witness Lloyd's testimony on page 25. Do you have his testimony in front of you?
I do. I'm here.
Okay. Lines 8 through 12 note that for PM 2.5, the companies chose not to use the Greenville ESC monitor, which is located 30.5 miles away, in favor of another monitor located slightly further away. Do you see that?
I see the section.
Do you have any reason to dispute that that's correct?
I can't dispute or agree with what he's included in his testimony.
Do you have reason to dispute that if Duke had used the monitor closer to calculate background PM 2.5, that it would yield a violation of the primary annual national ambient air quality standards for PM 2.5?
Again, I lean back on the process that Duke Energy followed, which was a protocol submitted and approved by DES for which to do their studies.
Okay. So you have no reason to dispute that?
Nor agree.
Okay. And for carbon monoxide, Duke relied on 2021 to 2023 data from a monitor located 100 miles away. Is that correct?
I'll take your word for that.
Okay. Okay. Thank you. Just a couple more questions. When you concluded that the impacts of the proposed facility upon the environment are justified, were you aware that the company's air dispersion modeling shows significant concentrations of nitrogen dioxide and PM 2.5 at each of the 3 elementary schools located nearby?
I'm aware they've conducted modeling. What was your question specifically?
Were you aware that the modeling shows significant concentrations of nitrogen dioxide and PM 2.5 air pollutants at each of the 3 elementary schools located nearby?
Based on the initial submittal of the application to Bureau of Air Quality, I understand that part of that air dispersion modeling is establishing receptor grids that extend out from the property lines out to 50 kilometers. And in order for Duke Energy to obtain air quality approval from the BAQ, all of those thresholds must be maintained. So with regard to what you're determining to be significant, I can't verify that specific number that you're referring to.
Okay, that's fine. If DES requires stricter emissions limits, consistent with what states in Alabama, Georgia, Virginia, other jurisdictions have required for similar facilities, you would agree that the proposed Anderson plant would conform to those requirements, correct?
Duke Energy will consult and coordinate directly with DES and follow their guidance as long as it meets the laws and regulations at that time.
Okay. Mr. Smith, do you agree with that as well? Happy to restate the question.
Yes, Duke Energy will follow the requirements provided to us in that permit once granted with from DES.
Okay. So you'd agree that the facility would be capable of conforming to those requirements from an operational standpoint?
We don't know what they are going to place in the permit yet. We're kind of in front of that, but fully expect with how we're proceeding with our application and our modeling, yes, our technology and our equipment can comply with what we are requesting.
And if DES were to require stricter limits in order to comply with that permit, would you agree that the facility would be capable of conforming to those requirements?
Stricter limits is pretty broad. I mean, within the realm of expectation, our equipment and our facility will be capable of meeting that permit requirement. Stricter expectations, if those numbers go to 0, I can't really address or answer that question today.
Okay. Thank you both. I appreciate it. No further questions.
Thank you very much. Any questions from any other party? All right, any commissioner questions? Commissioner Caston.
Thank you. Now it's good afternoon. I don't want to confuse my Smiths. I don't think it's Miss Smith, but thinking about this project as a whole, does the company consider this a baseload facility or just a big dispatchable facility, all the above? How does the company consider this?
Yeah, I mean, the terminology today is changing so much with the, trying to get to the renewables and figuring out exactly where you fit. But the simple answer is yes, we consider this a base-loaded facility. If you think about that terminology compared to what you may be familiar with 10 or 20 years ago, maybe the terminology is a little different. But yes, this is fully intended to be a base-loaded facility.
Thank you. And looking at the wet-cooled, air-cooled that the company did look at, were both of those considered at all the other sites, including the, what's the name of that site? The WS Lee site. Were both of those options considered at all the sites, or did it matter one way or the other?
So Duke Energy has a history for all of their generation facilities to use available resources that limit the cost of operations and services. And in the vast majority of cases, Duke Energy's facilities are located on a water body, a river, a lake, or somewhere where basically once it's permitted, the cost of that water resource has no cost other than pumping and chemical treatment and that sort of thing, but it's free water. And so from an overall utility perspective of trying to provide the least cost service to our customers, we always we lean that direction. What's the least cost alternative to meet the need of that site? When we look at, and my team works with the other teams within Duke Energy to look at other sites as we go forward, then we always have to look at a critical issue of water availability. And if we do not have water available at the job site or at the proposed site, if we're not close to a river, we have to consider alternate technology such as this air cool that consumes and returns 90% plus less water than a wet cooling system. So it always has to be factored in, provided that in order to eliminate any fatal flaw with a site evaluation, you have to consider water and what are your cooling options at that location. So I would say in most other sites that we do look at, you typically have surface water available that can be used for cooling. And so again, leaning back to the least cost alternative for that water source, we typically would go that direction, but always look at air cooled as necessary.
I thought that would probably be the case, but you answered it quite thoroughly, so thank you very much. And this may be more along your lines, Mr. Bass. I understand it, the total site is about 214 acres, 200-something acres.
Yeah, so we evaluated 214 acres. There's several parcels that Duke Energy has an option to purchase agreement on. So yes, the entire is about 214.
And as far as, I don't know if it would be the actual footprint, but the project itself, will it be pretty much on, I think, if I understood it correctly, about 51 of those 214 acres, is that correct?
So the footprint of the plant itself would generally be on that southern portion of the property, which is about 50 acres. But keep in mind, there may need to be other portions of the site utilized for construction laydown, parking, and other associated uses.
But those would typically be temporary or?
It's hard to say
Okay.
at this time.
So whatever's left, the acreage, any idea, any plans for that, do you know, or to be determined?
I'm not aware of any future plans.
No plans that I'm aware of for future other developments on the location. As Nathan mentioned, we probably will use 75 to 100 acres for construction, lay down yards, craft parking, and direct facilities while the unit's under construction. Many of those areas will be restored. Some of those areas may remain in small gravel parking lots in order to facilitate outage work and future activities related to the generating facility. But there are no other plans that I'm aware of for the rest of the acreage.
Thanks, gentlemen. No more questions.
Thank you, Commissioner Caston. Commissioner Brett.
Thank you, Mr. Chairman. And this question is for you, Mr. Smith. In your summary testimony, particularly the last page, that last sentence really perked my interest because it took me back to about 2 years ago when the BMW chairman of the board, Arnold Zipse, was making a big announcement in Spartanburg about Plant Spartanburg and the new plant in Woodruff. And he was talking about why they were so late to the electric vehicle market. But he made a comment, and right there, when you talk about the hydrogen blend, he said they thought part of the reason they were so late getting to this market, they thought hydrogen was the fuel of the future. So when I see that y'all are utilizing or want to utilize, if it's capable, a 30% hydrogen blend, if it's economically and commercially available, have y'all utilized that in any of the other Duke facilities?
So
Or
for
just
all of
cutting
the new,
edge?
For all of the new units that we're working today with this class of combustion turbine, this HA.03 unit, we are bringing those to the sites 30% capable out of the box with a 30% blend with natural gas. So we're going that path to start being prepared should the market transition in the future. Have we actually used hydrogen in generation? Only in a pilot case. And if you look at, we set up last year one of our combustion turbines down in Florida at the DeBerry site, and we physically demonstrated our capability to manage and operate that combustion turbine on 100% hydrogen very successfully. You're talking about a very small scale combustion turbine to the ones we're talking about today. So the scale and volume and infrastructure to support that volume of hydrogen needs a lot of development before that to become viable.
One last question, and I'll kind of piggyback on what Commissioner Caston was talking about, the air-cooled versus the water-cooled. It's interesting, again, going back to my Spartanburg council days, the last groundbreaking I did was with a company in Spartanburg that was building a plant right beside the Woodruff BMW facility. It's called Eris. And what they were specializing, they were bringing this technology and this manufacturing capability to Spartanburg and South Carolina. The governor weighed in heavily on this because they had developed this air cooling. So when you're asking, and I was paying attention when Commissioner Caston was asking, do y'all utilize this in other places? What I heard at that groundbreaking, this is very new technology, and a lot of the data centers, as well as hospitals and schools, are now capable. They've refined that technology, that they're able to use it, because not only does it reduce the amount of water that's used, and even though you're in the energy business, it also reduces the amount of energy, electricity that has to be used. So just sharing that with you, no question. I thought that was very interesting.
It is very interesting technology. One thing you said was very new technology. I would say the technology's been around for a couple of decades, and some utilities, especially if you think about utilities west of the Mississippi where water is a much bigger concern, utilities have been using air cooling for decades.
All right, appreciate it.
Thank you, Commissioner Britt. Commissioner Belser.
Thank you. Good afternoon, gentlemen. Mr. Bass, in your testimony and in your summary, you spoke to wetlands and streams, and I believe you indicated that the preliminary site impacts, that no streams or wetlands are impacted. Is that correct?
That is correct.
When we were at in Anderson for the customer public hearing. A couple of witnesses indicated that there was a stream on the project site, and they indicated concern over impacts.
There is one stream. It's called Beaver Creek that runs through primarily the northern and western portion of the site. And so when Commissioner Caston mentioned the 51 acres for the primary footprint, that is outside of all streams and wetlands. Whenever the EPC vendor is selected and they ultimately design all the laydown in other areas, there may be a situation where you need to put a culvert in to cross a stream in order to get to a different portion of the property. And in that event, the EPC vendor would work directly with Duke Energy in permitting that through either the Army Corps if it meets certain thresholds or through DES.
Okay. And I want to be clear, you indicated that preliminary site development plans indicated, I don't want to misstate what you were saying, but even if what you just described of having a temporary, would that be correct? A temporary crossing or temporary?
Well, I'm not sure if the access road will be temporary. Most likely in a situation like that where the laydown yard is in place for several years, they may go ahead and permit that as a permanent culvert crossing.
But anything having to do with impact to Beaver Creek would be coordinated and approved by the Army Corps and who else?
Of course.
Okay. All right. Thank you very much.
You're welcome.
And I would just add to his comments. I mean, anytime we look at a site and we develop it, first course of action is to avoid. And so, as Nathan was mentioning, some of the laydown in other areas, we have more flexibility with the shape and configuration of those, so we try our best to stay out of those or avoid them. But if there becomes a stance with the EPC setting up their site, there's an issue, it would be fully permitted through the Corps.
Okay. Thank you.
Thank you, Commissioner Belser. Commissioner Williams.
Thank you, Chair Powers. Good afternoon. Good to see you again. Mr. Smith, you talk about the benefits, as we've talked this morning, about the closed system air-cooled condenser and there being a water reduction of 90%. My question is just 90% of what? Is it kind of the standard operating mechanism that would have been used but for the closed air cooled condenser?
Yeah, so when you talk about a wet cooled system, you've all seen it. When you run by a power plant and you see a vapor plume rising, that's a wet cooled system where you're evaporating a lot of water. My testimony says 9.5 million gallons of makeup water for a wet cooled system for this size of generating facility. In my head, I round that to $10 million, 10 million gallons per day. So if you say 10 million gallon per day demand for makeup water for a wet cooled system, the dry cooled system will only require about 0.6 million gallons a day. So greater than 90% reduction from wet to cold to dry.
Okay, thank you. And you heard the discussion earlier with one of the other Smiths that's testifying today. How has Duke Energy responded to the customer concerns in terms of either how you're going to operate or how you've designed the plant?
I did attend the open house last Monday night, and it was well attended. We had nearly 50 neighbors show up and walked through the open house and asked us all a bunch of questions. I would say the two things that I heard the most were just gaining and trying to gather information around noise and traffic. And so what we explained to them from a noise perspective, we are buying equipment that is specified to meet near field, close proximity to the equipment, and far field noise limitations. Because we want to make sure once we get all the parts and components together, we can meet the site perimeter limits required by the ordinances. So we work with these suppliers and make sure we've done everything we can to dampen, to mitigate, to insulate, to enclose, to limit those noise sources. And then as we go through construction and move towards commissioning and startup, we will continually monitor both near field and far field noise sources to make sure that we are staying in compliance with those ordinances. So working with the suppliers, we feel like historically we know what they're going to provide. We know what we can do when we aggregate the plant, so we have high degree of confidence that we can pull this together. As also, as witness Nathan mentioned, it's been modeled, so they've taken that same information and modeled the results at our property boundaries, so we have high confidence in those numbers. I'd say the other thing was traffic, and clearly a concern that we all have had. We have taken the EPC contractor to the site once. We're just really getting in the midst of them understanding the full scope of the site and putting together pricing, but they recognize traffic is a concern on Highway 81. It's a high volume divided highway. So we are very concerned with how we egress that site throughout construction. Once we get into operations, it'll be a no never mind because there will only be a couple of handfuls of employees there. But we are working with them to make sure we're doing everything we can to mitigate traffic, to put it in a very safe conditions where we can bring hundreds, 700 craft in and out of that site each day.
This is probably addressed somewhere in the testimony, but I wasn't thinking about it at the time. But are there vegetative buffers that might impact air quality as well as noise on the perimeter of the site?
From a regulatory perspective or from just an existing conditions perspective?
From what will be there once it's finished.
Gotcha. So the southern portion of the site where the plant is currently has a number of transmission lines, and it's mostly in a cleared condition at this point. The northern portion of the site is largely forested, and we do anticipate that much of that forest cover would be able to remain, particularly on the perimeter. But it depends. From an air quality perspective, it probably doesn't impact it very much, if measurably at all. And from noise, you really need probably 300 plus feet to really make a difference.
And Mr. Bass, you talk about significant adverse effects to land use that you're looking at. How do you define significant? Probably asked you that before.
Significance,
based on the look on your face.
Yeah. So significance is tough to define because where do you look? One thing that comes to mind is the Council on Environmental Quality, which was established by NEPA, National Environmental Policy Act. They loosely define significance based on the context of a certain action and then the intensity of that action. And so that kind of gives us a gauge on where we can lean towards significance. From our perspective, we heavily lean on the local, state, and federal agencies and their technical experts to perform their research and establish certain guidelines that protect the health, safety, and welfare of the people in the community. So I think at its most basic sense, the ability to meet those basic requirements in order to get a permit for the work will in essence mean that a project's impacts are not significant. So that's how quantitatively we look at it, at least.
Okay. And to both of you, and it could be there's somebody better that I can better ask this of. I believe that in essence, witness Lloyd's testimony talks about if the Anderson plan is ultimately constructed, it underscores my recommendations that Duke Energy should take steps to invest in measures such as air monitoring and energy efficiency and air sealing improvements that will mitigate such impacts and reduce potential health outcomes. Do you all, either of you, have responses to that that testimony that's in the docket?
Well, I'll go first on that one. He lists certain conditions and recommendations that Duke Energy undertake, but just by the nature of the National Ambient Air Quality Standards, those are established to keep clean air clean. It's established to make sure that the most vulnerable populations are protected from actions such as developing new plants or any other action. What I can say is we heavily lean on the fact that if we can get the PSD, the Prevention of Significant Deterioration Permit, approved, that means that we are below the limits of those emissions thresholds. Therefore, we're meeting those national ambient air quality standards. Therefore, the clean air is still clean. So the mitigating measures that Mr. Lloyd's referencing, I personally don't think that they are necessary, given the fact that we would have an approved permit. But at the end of the day, if that's a condition that DES determined to be necessary in order to meet certain laws and regulations, that's certainly going to be part of that discussion once the final application is submitted.
Mr. Smith?
I would, and I'm going to refer you to Alicia, witness Alicia, on some of the other community things. I think if you look at Duke Energy as a whole, we have lots of programs, whether it's winterization, whether it's efficiency, air sealing, as mentioned in the testimony, referring to things that may be done in the local community. I think all of those things Alicia can address as far as Duke's commitment to the community there.
Thank you to both of you. I appreciate the answers.
Thank you, Commissioner Williams. Commissioner Cass.
Chair Powell, just to follow up, I want to make sure I don't exhaust my Smith. Only have one more.
I'm going to let you borrow my glasses. Can't tell the difference between the two.
No, they're three. Thinking about, without getting into the permitting issue, just kind of going back to my little background, when we would design for whatever facility, whether it's a wastewater or a water withdrawal, you had background data, what's in there, what are the requirements, what do we have to meet from a permitting point of view, and then what technology is available to meet those. And we typically do maybe pilot studies, whether it be membrane or conventional treatment or whatever. Thinking in terms of how the company pursues this, and I was looking at, I think I guess your focus or background is more on the generation technology and such. Is that true?
The selection, the permitting, and putting together the major equipment and the engineering construction procurement contract to take a project to the field for execution. So the front end construction estimate.
Well, I guess what I'm trying to get to or ask is similar to how other utilities that are not electric utilities design things in anticipation of meeting permit requirements. Does Duke do the same? Do you have an understanding of what the general requirements are, and you study and look at the technologies that are available, and how do you do that?
Yeah, I think I'm understanding your question, and yes, I mean, based on what is known at the time of the development activity, we write specifications for our equipment and our components of both performance and efficiency and emissions. All of that's defined by what we know to be law and regulation today. And so that information is then packaged together and given as requirements to the EPC contractor, who is then required to procure and purchase that equipment in compliance with those specifications. So yes, we have current day knowledge. We package it up as a requirement. We're doing this somewhat in parallel with these other processes and approvals and permits, and things can change along the way. Generally speaking, we evolve to the point that yes, we understand what the requirements are before we go under contract with an EPC. We have permits in hand, we have approvals in hand, so we know once we have those approvals, we know absolutely what those requirements are at that point in time, and that's what's reflected in the contract is that we purchase.
Thank you, sir. No more questions.
Thank you, Commissioner Caston. Any further commissioner questions? Mr. Smith, I think we all like what you said about the water, the air cool thing. That's makes a lot of sense. And gosh, that'd be a lot of water if you didn't do it that way. Awful lot. My question, either one of you, with this much property, and I know it's not part of a permit now, but if later it would be helpful, is there room for some sort of battery storage facility on this property?
I wouldn't rule it out. Yeah. I mean, when I think, when we start, my team comes together and we start looking at sites, the other witness, Smith, is coming up talking about site selection. But as we collectively look at site selections, I mean, we really want 200 acres to be able to build and manage construction for a facility of this scale. As witness Nathan mentioned, once we get done, you know, we're only going to be sitting on a footprint of about 1/4 of that acreage. So could some of those other properties, could they be used for battery storage or something? Assuming the transmission and all the other things that would be required for that to happen, I would say it could be considered. But again, none of that discussion is taking place at this point.
Thank you. And Mr. Bass, you talked about north of the property presently is woodlands. It's going to take about 5 years to get this thing completed, is it not?
Correct.
5 years from now, with the growth that we've seen in this state, there's no telling what's going to be north of this property, is it?
Well, let me correct the record there. So when I mentioned north of the property, the northern portion of the property currently is covered in trees. Just to the north of the property, you start getting into Anderson City proper, so you start to see development north of the property line.
That helps. Thank you. Yep. Any redirect?
Thank you, Mr. Chairman. Members of the Commission, I'll be very brief in my redirect. Mr. Bass, I want to ask you just a couple of quick questions. Do you recall being asked on cross-examination about emissions monitoring and the distance of this monitoring?
Correct.
And what was your response? Or let me help you. Did your response relate to, or can you address the companies? Did it adhere to state requirements?
Absolutely. So the existing monitors that were used are located in Pendleton. There's one in Simpsonville, one in Columbia, et cetera. And those are the established air monitors through the state for those specific pollutants. And so when Duke Energy conducted...
So can I interrupt you, please? So hang on for 1 second. You're saying that the state of South Carolina, the applicable agency that's charged with regulating those emittents in protecting the public, they determined where these monitors should be. Is that correct?
Duke Energy submitted a protocol, which included those monitors, of which they accepted, yes.
And so they reviewed it with their expertise, and they accepted that, and that's why you followed it.
Correct.
Okay. And then also you were asked some questions about back limits that apply to, quote, similar facilities. Do you recall that?
I do.
And these were some facilities in other states, correct?
Correct.
These, when you look at those types of limits, isn't it a very fact-specific analysis?
It's very fact-specific and site-specific.
So, in other words, would it matter if it was a CC versus a CT?
Oh, certainly.
And then, let's just say it was a CC. Would it also matter what vintage it was? Like, say it's a state-of-the-art one like this one as opposed to an older CC. Would that matter?
Absolutely.
Then let's just say hypothetically it might even be the same CC, same vintage. Would it matter where you located it and what your particular site looked like?
Absolutely.
Let's just say that it could be the same CC. It could be the same vintage. It could be the same acres. But wouldn't you still need to know the broader area that it's located on?
Absolutely. Every site analysis is done specifically to that particular site.
And so then really that's why, bottom line, in terms of any sort of permitting and what's best for a site in terms of air quality, that's in the purview of DES, and it's going to ultimately depend on what their requirements, their regulations are for our state.
Yes.
Okay. Thank you very much. I have nothing further.
Thank you. Based upon the question, is there anything further from any party? Anything further from commissioners? All right. Sure would like to get this thing moving, but it's lunchtime, I believe, and what we will do. I'm sorry, I did not have the mic on. Mr. Cooper, we're gonna break until 1:45 for lunch. And in the meantime, we're trying to figure out, just, you mentioned witnesses early on that we may or may not need to question. And somehow or another, we're gonna try and figure that out if we can, just to help the case.
And thank you very much, Mr. Chairman. And just finally, as we break for lunch, just subject to the normal procedures, we'd ask that these gentlemen be excused.
Yeah. Take them and feed them.
Thank you very much.
All right, we'll be in recess until 1:45. Thank you.